Welcome back. We'll have my session for the next 30 minutes and then we will hear Mr. DHANAPAL. So we'll get into the advantages of LLP form quickly. We've already seen this, but reiteration: fewer requirements to maintain statutory records, lesser government intervention, professionals can form multidisciplinary professional LLP. In fact, Companies Act has also built in a provision for having this, but between the institutes there are certain issues which the Vice President was also mentioning. Mr. Raghu was mentioning that they are still not game for having a collaboration between the CAs and the company secretaries and the cost accountants for some time to come. Company secretaries in whole-time employment and compliance certificate from the company secretary is not required. Designated partners are not required to retire by rotation, just like directors. Conducting meetings at specific intervals are not required, although it is required to form as a matter of good corporate governance, but not mandated through the Act. Auditor is not required to retire each year, and there is no cap on the number of audit entities that an auditor can audit. So what are the disadvantages of LLP form? Cannot raise money from the public. Yeah. No, we'll come to the audit itself a bit later. Yeah.
That is one of the advantages for a business person.
Okay. Okay. I mean, this is a new perspective because I was thinking more from the point of view of the auditors also. Yes, sir. Yeah. Yeah.
LLP having less than 15 lakhs contribution. LLP having less than 15 lakhs contribution or less than 40 lakhs turnover, they need not to get their accounts audited by a chartered accountant.
Yeah, that is there in the slide to come. But yes, this is one of the advantages. Otherwise, saying that a small LLP, like a partnership firm, does not need to be audited. That's one of the advantages. I mean, that I thought, since I'm talking to the chartered accountants, I should not mention that. That is a disadvantage to the chartered accountants. Okay. Okay. Disadvantages of LLP form: cannot raise money from the public, not easy to dissolve or wind up as compared to a partnership firm. For change in partners, change in contribution, share of partners, change in the share of partners, change in business activity, and there is a whole lot of other changes which one has to go through Form 3 and Form 4 very, very clearly. That form itself gives you how to draft an LLP agreement. The form itself says what is your clause on this particular resignation of a partner, clause with respect to retirement of a partner, clause with respect to admission of a partner. So that means that gives you an idea as to what are the various clauses that you need to otherwise build in your LLP agreement. That is one way of building your LLP agreement. The other one is to copy and paste somebody else's who has done a better job. Okay. So anyway, for every change you need to change your LLP agreement and inform the ROC also. Annual filing fee needs to be paid unlike a partnership firm, like a company. Heavy delayed filing fee, what we just discussed, the same thing, 50 rupees and 30,000 rupees being the additional filing fee. Lack of privacy, lack of confidentiality of the financial statements, which is available otherwise to a partnership firm, is not there for an LLP. LLP P&L, the income and expenditure account and the balance sheet and the notes are public, will be public, by paying 50 rupees, like in the case of a company, anybody can view the documents. Legal uncertainties. Newly introduced concept, yet to set its entire inclusive and exclusive terms in that sense. I mean, that is why probably the last one will be removed after today. I think they will get some amount of certainty. It is a partnership firm, all said and done. You can take a loan, not from the public, You can't go like in the case of a company, public issue nahi kar sakte. You cannot do a public issue. You can take from known people.
No, see.
Yeah, I mean, that is not considered to be public,
Can I?
That's yes, sir, please.
Can I? The known should be decided what is known that you mean to. See, whether it is a partnership or LLP or company, the moment you say subject to the provisions in the respective act, the moment you take loan from outsiders, it take a form of NBFC, non-banking finance. Okay, that can't be done by partnership LLP. And okay.
So, who are the likely yes, sir.
We cannot be formed as an NBFC activity.
Should not.
There is a bar LLPs to carry out NBFC activity.
No, there should not. Department, they came out, this should not.
RBI registers only private limited.
We have to register with the RBI. They came out. No, they are not permitting. We have not tried. We have tried. They are not permitting.
There is no bar. There is no bar.
Yes, sir.
You can. The only thing is you cannot go to the public at large and ask them to come and give you. No, sir. You can.
Bank you can take. As an individual also we are taking bank.
You can take loans. What I mean by public loans cannot be taken from public is you cannot just say unknown people can come and give like a FD. I mean, what is an NBFC? NBFC is like somebody coming to give and depositing their monies with you, assuming that there is some backing or something like that. That is not possible. Private loans, these are all, I mean, even if you take from the bank, it is on a one-to-one basis. It's a loan that you have, it's a borrowing. There is a difference between a borrowing and an issue. You are entitled to borrow, but not entitled to get deposits.
By the Reserve Bank of India Act, RBI Act, Section 45 MA. So that may restrict that. That is any entity it will restrict, not necessarily for LLPs.
That is what he's saying, but you can definitely take from banks. And then the next question is, I mean, which I will take up in the open session is, how are the banks taking LLPs as? I mean, that we will talk about a bit later. So likely beneficiaries of LLP, this is told...
We just ask something.
No, what do you mean by investor? Is he coming in as a contribution, as a loan, or as a capital? There is no concept of capital. He has to come in as a partner, contribution. As what? See, there is no concept of seed capital in the balance sheet. So it should be either capital, contribution, loan, borrowing, investment. These are the basic headings. One sec, let him. Just. Yeah. Yeah. Sure.
You should become a partner, sir, first.
Yeah, you have.
All I said is there is no bar against the seed investor coming in. He can definitely either join in as an investing partner and stay in the agreement, or he can just give the loan and enter the firm initially and subsequently take management rights, because at the next stage of funding which is there, you would definitely have to become a private limited company.
Yeah, this is very interesting, saying that LLP upgradation to company. I would like him to talk about that, what you just mentioned. Yes.
It is like we are restricted to one sector. If you want to do business in real estate, we will incorporate with real estate business. Can LLP have a different, like 2-3 sectors put together? Can they have, because partnership, because this is the agreement between the partners to do the business. Can I, 2 sectors, can I mix it and have a LLP?
More than 2, let us say 5 sectors. I want to be in hotel, I want to be in film production, I want to do real estate, I want to do chartered accountancy, I mean some consultancy also. So we'll ask this question to the ROC, because, I mean, why I mentioned this, there is no bar in the LLP Act. There is no bar in the Companies Act also. I don't know, this is more by... more by, I think there is an internal circular for the ROCs. Yes, I think you can answer this, but we can definitely ask this question to the ROC officials when they come. Yes, sir.
See, Section 149 under Companies Act 1956, which talks about commencement of business and with the different objects. In fact, that itself is saying that the section says if a company, they are planning to commence a object that is mentioned in the other object, they have to follow certain procedure, filing a form and pass a special resolution. That means indirectly the Companies Act permits. No, why I am telling indirectly, you can't have 10 business in a company. basically the department regulator, they ensure a company should concentrate on, it should represent the name. Suppose Reliance Industries, if they enter into software, the whole public will not get idea what the Reliance is getting into. For that reason only, the regulators, they ensure the company concentrate the core business what they represent the name. Otherwise, it's not that apparently they are restricted to do other business. That's first point. The second one, the Companies Act 2013, which is going to become effective, it has clearly come out that the company can have more than one business.
But still there will be, I also subscribe to the view, why should I not do 4 type of business in one company? That's one question. And nobody is restricting me. Okay? So the regulators are for a specific purpose. So we'll ask this question specifically to the regulators and then try to elicit more views. But as it stands, LLP does not curtail you from doing more than one business. Okay. This is listed out already. Service providers, new knowledge and tech-based fields, professionals. This is good for professionals. This is good for venture capital funds, good for MSME enterprises, and good for all entities wherever corporate form is not required, in short. But still have the benefit of, and I was telling this to Babu, I just removed my coat. I don't need a coat all the while. If I remove a coat and put a tie, that is LLP. Okay? Remove a tie, then it's a partnership. So I'll stop there.
Let us not go beyond.
Okay? Okay. No, there is no. It's already being done. LLP is, in fact, multidisciplinary, no.
Yeah.
That's what I think you were just out. I mentioned this, saying that Raghu in the last session, he said that for the moment, although the Companies Act permits multidisciplinary professionals coming together, practically it is yet to see the light of the day. Exactly, not by the regulators. So
as of now, the professionals can join together and form LLP for their own professional purpose, but they cannot do attestation service in the LLP.
Okay. So I need to quickly rush my session in the next 15 minutes. I need to wind up. So we will now have a monologue. So every LLP must have an agreement. If certain points are not dealt with in the agreement, the provisions of Schedule 1 will take over. So what is Schedule 1? You can have a look at it. LLP agreement versus memorandum and articles. This is a very interesting combination. What is the difference between a memorandum and an articles? Let's tickle our brains. We have read it somewhere in the first PUC, second PUC. Afterwards, we know what is memorandum and articles. Copy paste. But what is memorandum and what is articles? So memorandum, whenever we say, it is between the it talks about name, place, animal, thing. 5 different aspects of name, place, objects, capital, subscription. So these are the 5 clauses that need to be necessarily there in a
liability clause.
And the fact that it is having a limited liability. Then when you come to articles, what is articles? Articles are actually capturing all the regulations or how the internal management is going to be conducted. That is the bylaws, the internal bylaws, how it is going to be run. So that's what is told there. So what about LLP agreement? Is it like a memorandum or is it like an articles? It's actually both. It's actually both. Now that's what I'm trying to say here. LLP agreement. Now in the earlier times we used to talk table A. When we said table A, we were referring to articles of association. Now table A in the new Companies Act refers to memorandum, and table F is actually the articles. So we said table A, that means every company must have a memorandum. But for the purpose of articles, they can say refer erstwhile table A, now table F. So in the similar fashion, every LLP must have an agreement for all those as the name, place, whatever we talked about should be there, name of the partners. But with respect to share of profits, I may say nothing is told there, then you refer to Schedule 1, it says all of them are treated equally. Then admission of partners. In Schedule 1 it says if nothing is told in the LLP agreement, then the admission, new partner can be admitted only with the connivance or the concurrence of all the partners. So like that, the Schedule 1 goes on to list out If you want to say 75% of the partners agreeing is sufficient for a new partner to come in, that should be coming in your agreement. Otherwise, it is considered to be what is told in Schedule 1. So that's basically the difference between agreement, memorandum, articles, Schedule 1. Okay. So we'll go to the partners of LLP. Are there any qualifications? Any individual or body corporate may be a partner in an LLP. Any individual or body corporate may be a partner in an LLP. Now, who is a body corporate? Who is a body corporate? A company or an LLP, in short. Otherwise, the definition of body corporate is also given here. So, can a partnership firm be a partner in an LLP? Can a partnership firm be a partner in an LLP? Why circular? This itself is very clear. This is from the section actually. Okay. So, can an LLP be a partner in an LLP? Because it's a body corporate. Then individuals not capable of being a partner. People who are of unsound mind, people who are otherwise insolvent, and who have applied for insolvency. Now this is a very small thing. All partners should have PAN. So let's get forward. How? Sorry?
No, it cannot.
So how can a person become a partner of an LLP? By subscription to the incorporation document, or subsequently new partners admitted as per the LLP terms, and a consent of all the partners need to be obtained. Consent of the designated partners or the partners need to be obtained and filed with the ROC, like in the case of a director. Now this is something very tickling. Assignment and transfer of partnership rights is possible. What do you understand by this? Assignment and transfer of partnership rights is possible. I am a partner with 90%, Babu is with 10%. I can say 50% of mine I will share with Mr. DHANAPAL. DHANAPAL is not a partner in the new LLP, please understand. Its partnership is only between me and him. But the rights associated, that means the share of profit, whatever, 50% to him, 40% to me, 10% to him. So as far as the LLP itself is concerned, he cannot be considered as a partner. Otherwise, it will be amounting to admission of a partner. So assignment and transfer of partnership, please note this is also there in the Partnership Act, Indian Partnership Act 1932 also. Okay. We'll talk to Sachin. Sachin has wonderfully covered that. I saw his presentation. He has wonderfully covered that. There's a very debatable issue whether it is a capital asset itself, and not only at that time, afterwards also. Even if he is admitted and he gives me goodwill, whether that is subject to tax, that will be a very interesting discussion, which we will have. All interesting discussions after lunch. Now we wanted income tax to be after lunch. Yes. How can a person become a partner? I think this is how can a person cease to be a partner in accordance with the LLP agreement or in the absence by giving 30 days notice? A person can also cease by death or dissolution, or if he is unsound mind later on, or if he becomes insolvent later on. And file notice with the ROC when a person becomes or ceases to be a partner. Every in and out of a partner needs to be, otherwise for 50 rupees you end up 30,000 rupees. No, this is the 30,000 can be 60,000 within 30 days in Form 3 and Form 4. Obligation of partner if he changes his name or address. If the partner changes his address, there is a need for him to inform the LLP in 15 days and for the LLP to inform the ROC in 30 days of the change. So what are the rights of the partners? I think we have covered this. We will not get into this. Designated partners. Only partners can be designated partners. I mean, it is not like an independent director or something like that. So only partners can be, and only individuals can be designated partners. So we leave it at that. And one of the designated partners necessarily needs to be a resident in India. This aspect, as I was telling you, was always there in LLP Act, now brought in Companies Act 2013 to say one of the directors should be a resident director for more than 182 days as far as the Companies Act is concerned in the previous calendar year. As far as the LLP Act is concerned, in the previous 1 year. I mean, there is a small, so previous 1 year means what? Financial year or calendar year is a question mark unless you have a issue. I mean, you have an answer. Now, if no designated partner is told, then all the partners are considered to be designated partners. Additional disqualifications also told in the rule. I mean, designated partner ke liye there are only few restrictions. For being a designated partner, if he is considered to be a, he's imprisoned and of moral turpitude, so many other additional disclosure. This thing has been told in Rule 9.1 of the thing. I'm not taking you there. Every designated partner must have a DIN. Earlier it used to be called as DPIN. Now also in the various forms it is considered as DPIN only, but what you are supposed to give there is the DIN. Now, at least 2 DPs should have digital signatures. So what are the job or liability of a designated partner? Accountable for regulatory and statutory compliances, liable for all penalties imposed on LLPs for any contravention. The DPs are also supposed to go in for appointment of auditor, signing accounts, filing all relevant documents, and acting on behalf of LLP in case of winding up. What are the liabilities of the partner? When will the liability of the partner become unlimited? That's what we are trying to see. If they have committed a fraud, that is one context. If the number of partners fall below 2, and such a business carries on business for more than 6 months, in such context, the other partner's liability will become unlimited. And under the Income Tax Act also, Section 167 of the Income Tax Act, which got introduced in the Finance Act 2009, goes on to say that the partner's liability with respect to tax payment is always unlimited unless the partners can prove that they were not responsible for the default. Okay. I will try to discuss this with Sachin. Because I'm just trying fast. I will note down your point. We'll come back to 167C in the third session. I don't want to eat too much of his time. Okay. Very beautifully brought out. In the Act itself, it is brought out, that particular section, but I will come back to that. Now, we come to accounts and financial statements. Is an LLP required to maintain accounts? Yes or no? Yes, like in the case of a company, it is supposed. Are they supposed to follow cash system or accrual system? Companies have been told to follow accrual system, whereas LLPs have been given the liberty to follow either the cash system or the accrual system using double entry system of bookkeeping. I wanted to ask one question. What is the difference between accrual system and mercantile system? Can you think of what is the difference between, I'm just going very deep. What is the difference between accrual system and mercantile system? Accrual system is discussed in the Companies Act, in the accounting standards, all other places. Mercantile system is used in the Income Tax Act. Section 145(2) talks about mercantile system. So mercantile system and accrual system actually mean the same. I just was trying to get to the genesis of the word mercantile. Do merchants use mercantile system? And that's the question I wanted to discuss in some other forum. Now, every LLP to maintain the books in the registered office for 8 years, that is. And financial statements, no format prescribed, and Form 8, we have already discussed that the template is there. This is what is very interesting. Uniform financial year has been told for the LLPs also, like in the case of a company. For the first year, there is some deviation. I am not getting into that. Contribution, we have already discussed. No minimum contribution. There is no minimum contribution, like in the case of a private limited company, 1 lakh, and public limited company 5 lakh. Here there is no minimum, even with 1 rupee, but everybody has to contribute. Each partner has to contribute. Only reserves and surplus, that debate we already had, so we will skip that. Now we come to the very interesting part of audit. Audit required IFF, which means if and only if total turnover exceeds 40 lakhs or total contribution exceeds 25 lakhs. Now, this was a very interesting question which we did not delve into. Can contribution come down? Can contribution be 2 crores in 1 year and 20 lakhs in the next year? Yes or no? The answer is a big yes. And it has been so built in Form 3 itself. Opening capital additions and deductions and total. So contribution can also come down. But there is a very interesting thing which says if the contribution is coming down, it should be with a proper notice to the all the creditors, outside creditors. Okay. Now that was leading to a question as to when we say 25 lakhs, as on what day was one of the question that was raised. That is not very clearly told in the LLP Act itself, as at the beginning, during or end. So that will be a point to be seen. If the partners otherwise opt for audit, even if it is lower and the partners otherwise opt. Central government may exempt any class of LLPs from audit requirements. Rules regarding audit. Auditor appointed for each financial year, unlike in the case of companies when he is appointed once in every 5 years or 6 years is a question mark there. You know that. For every 6th year. So that will be an issue. 30 days before the end of financial year and by designated partners. Casual vacancy or vacancy caused by the removal of auditor to be filled as and when the need it arises. Remuneration of auditors to be fixed by the designated partners or as per the LLP terms. Removal of auditors are as per the LLP agreement or in its absence by consent of all partners. Resignation of auditors by notice in writing. So that's about it. Now we come to the annual filing. A distinction between annual filing, we have already seen financials and annual return. Form 8 and Form 11. Form 8 has to be filed, that is the financials have to be filed within 30th October. 30th October. 30 days from the end of 6 months. That is what they have told. 30 days from the end of 6 months, and you will have to, anyway 31st is the 31st of March uniform financial year. Okay. So annual return has to be filed within 30 days from the end of 2 years. 2 months. I don't know. Anyway, 30th May that is. Signatories to the annual return. If the turnover is less than 5 crores or if the contribution is less than 50 lakhs, designated partners. In all other cases, Mr. DHANAPAL also has to sign. Right, sir?
PCS has to sign.
Practicing company secretary needs to sign. When we talked about the filing fees, if it is within the prescribed period, normal filing fee, if there is a delay up to 300 days, additional filing fee of 100 rupees per day, delay beyond 100 days, they have very loosely worded it, that will also continue at 100 rupees per day. Compounding provisions applicable. Financial disclosure for second and subsequent offence, twice the amount of fine plus imprisonment wherever applicable. Companies Act also contains a similar provision. General penalties are also there. I'm not getting into that. LLP and FDI, let me see if I can touch this in the post lunch during the last session, that is. Foreign LLP provisions are there, and issues in general. What I mean by issues in general, we will probably have issues which we will discuss in the last session, that is. And what are the LLP few corrections? LLP forms refers to DPIN, as we saw. Actually, they are referring to DIN. And in form number 2, when we fill form number 2, details of body corporates as designated partners is also, there is a column. Actually, there is no provision for a body corporate to be a designated partner. And in form 8, this is very interesting. Should the ROC, when it borrows money and creates charges, file an equivalent of form 8? What we file, the creation of charges with the ROC. The answer is, there is no form to be filed as such. But in the form 8, form 8 here refers to the annual accounts and solvency. There is a column where they say creation, modification, satisfaction of charges. That means to that extent there is a...
It can be used for both purposes.
It has to be told at that stage and not... But this is to be done.
The form 8 can be used for both for filing of the accounts and for charges.
So you file the charges. Suppose I do it now.
There is an option is there whether to file accounts or for other purpose. That means when you click that option, you will get all the charge related portion enabled.
This is a very important and a learning point for me too, saying that if there is a charge to be created, you use form 8 of LLP
Same.
also.
Yeah. Same form.
So there is no such requirement that like unless in companies within 30 days you have to create a charge. Here Form 8 due date is there only to file.
It is only through the forms that we get to know that such a charge has to be created.
There is no provision in LLP Act to create charge. But they introduce a form. Probably they expect company to LLP to file charge. But otherwise, I doubt how they can take action and which provision they will invoke to take action.
Now, that is a bigger. It's the guard. The engine should drive the train. It's the guard who is driving the train from the last bogie. That's how it looks like now. So that's the miss. Sorry. These are all the issues that is actually. That's why it's left as corrections required in that particular act. Rules does not contain any provisions. So I stop here my session and say that when the going gets tough, the chartered accountants and the company secretaries also get going. So thank you very much. I come to the end of my session in particular. Okay, and I would now request the management to take over the proceedings, and after that, Mr. Dhanapal to give us his gyan. Thank you very much.
On behalf of Bangalore branch of SARC, I must mention our deep sense of gratitude for CA Gururajacharya for educating and enhancing our knowledge on distinguishing features of LLPs, partners and their relations, contributions and financial disclosures. Please accept our thanks for your great presentation, sir. Now we have with us one more speaker on the dais, CS S. Dhanapal, who has come all the way from Chennai to speak on incorporation of LLPs, conversion of partnership firms and companies to LLPs. Now, I request our Vice Chairman, C.A.K. Babu, to come forward and formally welcome our speaker, C.A.S. Dhanapal, with floral bouquet. Now I take this privilege to introduce a person who is a passionate reader, voracious speaker, and a prolific writer in varied legal and secretarial matters. That is C.S. Dhanapal. C.S. Dhanapal is a fellow member of Institute of Company Secretaries of India and a law graduate from Dr. Ambedkar Government Law College, Chennai. He has around 15 years of experience in the areas of secretarial and legal matters and has undertaken statutory compliances and audit under various corporate laws. His major areas of practice are amalgamations, mergers, and scheme of arrangement and reconstruction of companies. His regular appearance before Company Law Board and his experience in the areas of FEMA. He has also authored a book, LLP Made Easy for Corporate Professionals. He is a visiting faculty to handle management skills, orientation program, executive development program. He is a regular article contributor for various journals. With this brief introduction, now I hand over the session to our speaker, C.S. Dhanapal.
Sir, Mr. Dhanapal, you are not new to Bangalore. You are not new to any of us actually, and most of us receive your wonderful presentation. I am sure all of you have received it. That's what he says. He sends it to all the chartered accountants of South India, and it makes a very interesting reading. We thank you for sending the material on, and keep up the good work. In fact, we wanted to call him for the Companies Act workshop itself, but his time was not suiting, and therefore we had to reserve him for this particular session. So we thank you very much for coming all the way from Chennai and being here and being with me, supporting me in the session. So over to you, sir.
Chairman, Bangalore branch, CRC of ICAA, Vice Chairman, and senior members and members sitting here. Good morning all. In fact, in every context and concept, I wanted to deliberate more. In fact, I don't want to take his time and deliberate more. I thought when I get my time, let me utilize it proper. And LLP as it is, there are so much to deliberate. If you see the substantial law, we can even deliberate in a matter of hour. If you take it as a debatable law, you can deliberate in a day also. The problem is, this is a hybrid system where it combines both partnership and company. This is not like a company which is completely governed by a special statute like Companies Act 1956. Now, of course, we are in a pathetic situation. Not only to refer Companies Act 1956, I should also refer Companies Act 2013. And we are in a position to carry 2 barracks for a single act. And according to the sections which we have to deliberate, I have to see that which act I have to refer and which provision I have to refer, in which act I have to refer. But fortunately, unfortunately, the LLP has taken shape, as he said, after much deliberation, more than 6 years. In fact, the mark started long back, in fact, to say that. Almost I can even show the record, it started 15 years back. But as usual, anything in India, we will be always be the last person to get advantage or get used to that, just like a car or whatever it is. The act also took a turn, the entire world. Almost every country is implemented. India alone, they were just keeping it back, and fortunately they came out with the decision, and 31st March 2009 they notified it as an act. And the rule for LLP has got notified in 1st April 2009. In fact, I was really happy to see that LLP is getting this much recognition and deliberation. More than 15-20 forums which I have done, a CA forum all over South. I never got a deliberation and never get into from participants. In fact, that's why the last more than a year we never took up LLP at all, because nobody is getting into. Now probably directly, indirectly, now we are influenced by introduction of Companies Act 2013. Now we made to think about LLP Act. How I will try to explain little later after once I cover. Probably I can give little more points on that now, so that you will pay little more attention on LLP. In fact, now the really is high time to learn about LLP. Leave it all the 4 years which you have passed already, fine. But now, whether we like it or not, now it's going to be the order of the day. It's not that just to promote LLP or to avoid Companies Act, public company, or it's not like that. As it is, the government has come out with a complete code called LLP Act and permitting us to form the LLP. The only thing is we have to understand where and all the advantages and what kind of entrepreneur and what kind of benefit they want from the law and which act they want to follow and which entity they will be comfortable to go with. It's not that something we are following LLP Act or we are forming LLP and avoiding other statutes or entities and we are not giving proper respect to the other act. It's not so. The reason why I have taken up an introduction on this, the new Companies Act 2013, which may expected to be notified any time, not sure, but still is expected to get notified any time, except that 95 which has already got notified. In fact, most of the provision, as I deliberated when I was sitting with the previous speaker, that most of the provision becomes stringent for private company. As he was correctly pointed out, the whole intention is why there should be a private company at all. If at all you want a format as a company, better to have public company. Suppose you don't want to get into the trouble of compliance or taking the pain of all accounting and other compliances, then better you go for LLP. Probably this might be the whole idea of the government, that they completely given effect in the new act, which they have not done in the old act. They have not brought any amendment to show this intention. But by bringing this Companies Act 2013, the real intention of the government must be this only, that if at all a company, better to follow all the rules and regulations. Suppose you don't want to follow as an entrepreneur, as a corporate, as a professional, better you go ahead with the LLP, as anyway it is very much available at the reach of the entrepreneur and professional, and got notified in 2009 itself. So, if I am not wrong, the future going to be more of LLP than private company. I can, even now itself I can assure. The reason being, as previous speaker told, the introduction of section 185 of Companies Act 2013, it not restricts, it completely prohibits. Where is the time where we were completely exchanging money and we were lending, borrowing, giving loan to the corporate, where we promote and where we extend our financial assistance to our external arm. Now the time has come, we are sitting now, we can't even pay a single pie to the other company, which we promoted, which is coming under our shade or which is there under our shelter. I don't think practically it would be possible. In fact, I should rather say it's a burning issue only. I don't know if this session reaches to the government authorities, they can rethink again to some extent dilute the provision to see that existing companies are surviving. It's not that new companies they have to start and do all that. But the company already got promoted. I handle many groups and come across many companies where they've got 20 companies, 30 companies as a group company. And they do many projects in the name of company in the form of SPV. Without money going from the parent company, those companies cannot perform, cannot exist at all. And there are so many other restrictions is there, which in fact, this is supposed to be the Companies Act 2013, which I could have deliberated more on that. Since being a topic of LLP, I thought little I can link and take a reference from the Companies Act 2013 and why we have to more concentrate on LLP. That we need to understand. Then we will concentrate. Whether we like it or not, we will concentrate. We have to concentrate. If we want to, rather I should say we want to avoid. No, it's not avoid. Suppose we want to do comfortably the business without getting into the nitty-gritty of the following of many of the provisions. Some may not be practical to follow also under the new provisions of Companies Act 2013. Now the LLP, which has come in 2009, hardly very few registration has happened in the first year, then some more few registration. Now only it is reaching in thousands, that too not even a 5 digits, it's still in a 4-digit level. Why this response, this has not got the proper response? The reason being the penalty. Basically, the concern of in fact, this was represented to the authorities also many times in many other forums. Because of the penalty only, it didn't pick up. But now, no other way, we have to take a decision whether we are going ahead with the penalty and see that we make ourselves disciplined and do everything on time, failing which make more penalty, pay more penalty, or form as a private company or be a private company and follow all the restrictions and do the business by following all the provisions of Companies Act, which has already got notified, which yet to be notified. This decision is ours only, probably yours only, probably the entrepreneur. We will move on to LLP. Wherever you have doubt, we can deliberate more. As I told you that now the day is going to come where we have to more think about LLP formation only. As many members here deliberating, they were having concern about who can form an LLP. In fact, without understanding the basics, going into incorporation and filing of form, of course, by now many of you would have done incorporation. It's not that something I have to teach you or tell you that how the incorporation has to be done. Probably few would not have done. We can cover that also and quickly. But before that, we have to understand basically which can form LLP. Company, we are little settled. As it is 1956 Act, almost in the retirement age and getting retired also. So we are little comfortable and have got precedence also lot who can form company. LLP, it's not the same. We need to come across lot and we have to try it out only, but subject to the provisions of the LLP Act. And many questions has come whether partnership can be a member, HUF can be a member, and what not. Let us address this issue first. Who can form a LLP? What Act says? If you see section 12, in fact, for the benefit of members, I want to read so that you will understand the real importance of the wording. Section 11, if you see, incorporation documents which can be registered as LLP. The wording starts, for a limited liability partnership to be incorporated, two or more persons associated for carrying on a lawful business with a view to profit shall subscribe their names to an incorporation document. Why it is important? In Partnership Act, you can see almost same language. Any two or more person join together to do business with a profit motive. There also in writing is missing. Here also the in writing is missing. Fine. But for all purpose, they have taken the provisions of the Partnership Act to define. In fact, there the partnership firm is defined to say that two or more persons join together to do a business. But here, they brought it a matter of, though there's a definition is there, they brought it in the requirement of the registration under section 11, that two or more persons associated. Okay, now let us see all that procedures and all that's usual that we can anyway learn. This we can't learn, we have to deliberate and find out what and all we can try out in future. Persons, who are and all persons. Any definition is there in the LLP Act? No definition is there. Any definition there in Partnership Act? On person. We deliberated more on partnership form also. Who can be a partner? Any definition? There is no definition. Can you tell me any statute, any law which has got definition for person? Income tax covers? You can be open. In fact, I'm telling you, we have to find out some new avenue and find out what are the possibilities by deliberating more. What I know, if I tell, then it will end with that. There is no scope of improvement. Income tax, what defines as a person? Income tax. I'm asking income tax. I'm not asking stamp act. I should not get silence from you as answer. Come on, someone. So I think anything I can talk and go. You will not open your mouth then. Okay. Yeah? Okay, great. Then? Great. Good. Whether that binds LLP Act? No, either the provisions of the income tax with respect to person definition, it binds the provisions of the LLP Act. No. Any other act that has got a definition for person? No, we are finding out a way out. It's not that simply we are. Tomorrow our client comes and asks that I want this entity and this entity to join. Can you form LLP? The first answer itself, if you say yes also you are gone, no also you are gone. Unless we understand what is the basic crux of what is the legal sanctity or what is the legal base by which LLP can emerge and can be registered, then nothing can be done. In fact, the one more statute which talks, to my knowledge, General Classes Act. Okay, generally where any definition is not, it's not properly defined, we can always refer to the General Classes Act. I can take a reference from there also. It's not that like Income Tax Act I cannot take. General Class Act is an act promulgated only for that purpose, where the entire laws of land does not able to mean something. Suppose the same meaning is available under the General Class Act, that can be taken as a reference. What General Class of Act says, it's an inclusive definition only. And it includes body corporate. It includes legal person. Fine. Whether partnership is included, suppose partnership is included also, can I form a LLP with the partnership firm, two partnership firm? Assuming it is included also. See, basically, this is not a question that whether the definition covers that person. It's not that. Basically, the legal sanctity that carries. What I told you in the deliberation, previous deliberation, that a legal entity is the only entity that can represent outside, representing the entity. As a partnership firm, it being an entity, not a legal entity, it can't represent as a legal entity to join together and sign. Of course, there are contracts are executed by the partners on behalf of the partner firm. I'm not coming to that point. As a partnership firm, the partner signs an agreement. Will it not be enforced? No, it will be enforced. Enforced under what? It will be enforced as a contract. Under contract, Indian Contract Act. So it's not that partnership per se permits or give authorization to a person to enter in a contract and that contract can be legally valid. Not so. The reference always be taken from the Contract Act. Even that's the reason, even partnership need not to be in writing also. I can even have a oral partnership firm in India. I can still, without signing any paper, I can say I am in partnership with Mr. Acharya. Nobody can question me. Not in professional thing, I am telling in a business parlance. Because our Indian Contract Act recognizes oral contract also. And the Partnership Act doesn't provide the partnership should be in writing. It says two person only should join. That too for a lawful business with a profit motive. This is what it says. So here the person, the reference alone can be taken, but we also should ensure whether it's a legal entity to do that. The person does not include a lunatic person, unsound person. For that matter, can they enter? No. Contract Act is not permitting it to enter in a contract. Something is not permitted, cannot enter. So what I'm trying to say here is not only that we have to understand what is person, we have to also understand what is the legal sanctity that something can be done by such entity. Here, as I told you that the person under General Class Act, it includes, it's an inclusive definition, and it includes body corporate. What is body corporate? Again, can you tell me anywhere the definition that body corporate appears? Definition of body corporate? Yeah. What does it mean? Any answer? Anyway, separate legal entity, fine. My one answer. Fine, again it's an inclusive definition only. That's what I want to try to say. But it excludes, that's more important. It excludes corporations, whole and cooperative societies. That alone cannot be a body corporate. Otherwise, everything else can be included. For that matter, partnership cannot be included. That's what I am trying to say here. We can't say simply something is not there, I will wherever possible I will bring my term there. No. Basically, a person should have a legs to stand. The capacity to hold, an artificial person cannot have unless he has got a legal binding or legal backup. As a natural person, now we have legs and hands to carry something, hold something. For an artificial person, there should be legal backup to make it as a legal person. That's what we have deliberated in the first session. where an entity which is not a legal entity cannot hold the property in its name. Because it will not have a capacity to hold the property. When you don't have a capacity to hold, how you can hold the property? For all purpose, you are not keeping the property, you are not holding the property. But what we do is, we put a partner name and make one individual is involved in the sale deed. And we make some way the document is, can be made usable in court of law. So basic understanding is, to be a partner in a LLP, basically it should be a person and it should be a legal entity. And individual is by default is included. An individual and corporate can join. Two LLP can form a LLP? Fine. LLP and company? So anything is possible now except a non-legal entity. Let us understand like this. Because we can list out so many like this. AOP, HUF. We can't keep on putting in our mind whether that will come and this will fall in that. No, you please apply the test whether it is a legal entity, whether it is capable of acting on its own. Above all, whether it is emerging out of law. What is that emerging out of law? Fine. Partnership also we have got to act. Right? Then it must be a body corporate or it must be a legal person. It's emerging out of a law only. No. Partnership, it defines what is partnership. That association is defined by a code. But that association is not emerging out of the code. How we can differentiate this, how it's emerging? In fact, in LLP section 14, effect of registration, if you hand you can see that one. Everybody has. Good. So interactive. On registration of LLP, limited liability partnership, shall by its name be capable of be issued, acquiring, owning, holding, developing, disposing of property, whether movable or immovable or intangible. Having a common seal if it decides to have one. Then if you decide not to have, you need not to have. Fine? So LLP need not to have common seal also. That expenses also is not there. If we decide and incorporate in our agreement also like that. And doing, suffering such other acts, here alone I am little, what they want, why they use a negative terminology, pessimistic kind of thing. Doing, suffering such other acts, things as bodies corporate may lawfully do and suffer. So fine, probably their mindset, how it would have been, I don't know, while drafting this law, they would have put. See, a LLP without registration, it cannot emerge. And a company without registration, it cannot emerge. A partnership without registration can emerge. And proprietorship without registration can emerge. A HUF without registration can emerge. Something emanating out of a law or portion of law, that always be a body corporate or legal person. That's what the whole thing which we have to basically understand. By applying the test, we can basically understand a entity whether it's a legal person or not. When it is a legal person, no one in India can stop us from registering. As long as we can prove it is a legal person, subject to our laws of land. Fine. Society cannot be. It is promoted for a different purpose. That purpose is not for the business purpose. Society, what purpose it is formed? No. Yeah, I want more from you. A society is generally formed to regulate the members, to regulate something. It not formed for profit motive. Generally, cooperative society, it forms for profit motive, but it is excluded from the body corporate definitions. Okay? That's the reason. We have to apply so many tests. That's what I'm explaining the whole thing. What are the ingredients that we have to see, whether it's for a profit purpose, whether it is a person, whether it is a body corporate, or whether legal person. All this test should be applied. Fine. Why I am explaining this, that it's so important to show my PPT so that you will understand why I am describing the characteristics which the input is given to you also. We will move on to PPT now so that you will understand basics. What is LLP? As I told you, it's a hybrid system. I will quickly move on because in fact I have not customized my PPT to this session. As I am coming out with a book for company like 2000, I am in the proofreading. I am supposed to make it published by next week. So in Haribari, when he requested, I said okay, and what are the PPT that I presented there, little I made customized and done. So I will be covering entire aspects. Wherever Mr. Acharya says stop, I will stop. It will run only till that 10. And our previous speaker, Mr. Acharya, is covered in a great way and nice way. So I don't want to spend time more on that. So that one day I was telling that the idea was mooted in 1972. Yeah, exactly. That was the mark created that time only. That's what I told. In the initial of this thing, as usual, we debated a lot, and we were hesitated to bring something new. And end of the day, only in 2009, we could able to see the light. So it started in 1972, and the committee itself, many committee it has come across. I can show you a big list also in that. Yeah, I am skipping that. Yeah. Without that, I am skipping only. Yeah. Now, for this reason only, I explained the whole thing. Because suddenly, if I show this, you will not understand what is this. Why we have to go back to our inter and final, which I have done long back. Understanding what is characteristics, what is basic. Without that only, we are sitting here. No, without many things only, we are sitting we are there in the world. But sometimes we presume that we know. Probably what we know may not be right and would not have understood that proper context. So for that reason only I put all this. What is this characteristics? How this characteristics comes out from LLP? When the LLP is registered as referred in section 14 of the LLP Act, when it is registered, it acquires all this character. Otherwise the LLP will not have this character. Separate legal entity, enough we debated. Limited liability, of course everyone aware, to the extent contribution, partners are liable. Perpetual succession, men may go and come, explained already well. Mutual rights and duties, it's already defined in Schedule 1, otherwise it should be in the LLP agreement. And separate property, only when it is registered only, an LLP can hold the property. Otherwise it will not have a capacity to hold the property. And sue and being sued, pursuant to section 14, only on registration of limited liability only, it acquires the status of sue and being sued. In fact, under Partnership Act also, only for that purpose, only privilege it gets when it gets registered. In fact, under Indian Partnership Act 1932, an unregistered partnership is as equivalent to the registered partnership. Only in one exception, that an unregistered partnership cannot sue outside, the outsider cannot sue the partners if it is unregistered. Except that privilege, no other difference between the unregistered and registered. But here, without registration, the LLP cannot come out. It can't emerge. So once it is registered, it acquires all this character and nature. And partner is the agent of LLP and not of others, as our previous speaker explained well. Capital contribution. In fact, I will little more explain on the portion when I am going to deal with section 32 on capital contribution. We will try to understand what it is exactly when that portion comes. And flexibility, of course, is there, and the rigidity also is there. Accounts and audit, enough deliberated. Investigation of affairs, a equivalent provision of section 234 of the Companies Act 1956 is implanted in provision of the LLP Act 2009. And the same procedure is followed, and the same procedure will be followed in LLP also to do inspection and investigation. There's equivalent provision is available in LLP. And whistleblower policy, a very good policy giving protection to the partner, and similar concept is going to come under New Companies Act 2013, which is not available under 1956 Act. Conversion to LLP, which we are going to see as a separate slide. Merger and amalgamation, very interesting, which may not cover, I may not cover in the subsequent slide, which I will deliberate here itself. Whether company and LLP can be merged. So we have not gone to that level. First of all, we have not registered LLP at all. Where is the question of merging LLP? No, it's happening. In a company court, almost every day, 2-3 cases are coming on mergers and demergers on LLP. So we are only not aware. Then we are dealing with the cases, and we could able to see many LLPs. Of course, I have not dealt with. Many LLP cases are coming, and proceedings is taking place only in the company court. But is it possible company to LLP, merging company with LLP? Demerging LLP and hiving of a division from LLP and merging with the company? Partnership and LLP can be merged? No. Any doubt on this? Is it? Fine. I'm okay. I'm just taking input. Then we'll deliberate. Under section 391, in fact, we have to say section 390 of the Companies Act 1956 that defines what is transferor company, and 390 to 395 which talks about whole entire scheme of amalgamation. Why I have to refer Companies Act? Because we are talking about merging LLP with company only. Is there any provision of merging LLP with the company under LLP Act? Anyone has come across? Is there any provision of merging LLP with another LLP under LLP Act? Fine. Better to come out. Because now only we are picking up an LLP, no? So probably next 2 years later you will be completely bombarding only. Fine. As of now, the provisions of LLP, provision of LLP Act, it permits merger and demerger of LLP with another LLP. Then that means it's not permitting merging LLP with the company. It's not permitting. But companies are permitting LLP to merge with company. See, there is a lacuna in that. If we understand probably why I am telling all that, there will be occasion will come where the LLP may be expected to merge with the company. Probably now to avoid the seriousness of the provisions of the Company Act 2013, will be forming the LLP now. Then again we may trap into this thing, and we again will try to convert the LLP into company. That time we have to refer the Companies Act only to see that whether LLP can be merged with the company. I'll tell the scenario. As of the scenario, there is no single verdict as if the company has merged LLP to my knowledge concern, but cases are there, proceedings going on to merge LLP with the company. How it is possible? There is no provision in the LLP Act. Neither it permits nor it prohibits. But under Companies Act, section 391 read with 394, it says a transferor company includes body corporate. That means a body corporate can be merged with the company. What we are discussing is the LLP is a body corporate. It is emerging in out of Act. Advancing this argument only, the cases are going on the court. But till now, there is no completed thing which I have come across that, but court has accepted this argument, and with this advance of argument only, the schemes are admitted, though it's not get approved so far, but schemes are get admitted where the transferor includes a body corporate. So taking that as a clue, the company court can take a view that LLP can be merged. We have to wait and see. Once we come across, probably a precedent will be created, then we can start doing that.
Just a word of additional point here. Body corporate has been defined both in the Companies Act and as well as in the LLP Act.
LLP, yeah.
Whereas LLP Act specifically recognizes company as a body corporate. In the Companies Act, body corporate says body corporate means a company which is incorporated under this act, and any other act, I mean, which if it is if it is notified, that means until that particular thing gets notified, the LLP as a body corporate by the company, by the central government, then it may not be considered as a body corporate under the Companies Act. I mean, to that extent, there is a different definition of body corporate in the LLP Act and in the Companies Act.
And only for the professional purpose only, it is not considered as a body corporate. Otherwise, the LLP is a body corporate for all purpose. Fine. So now with this, yeah. Nothing come to my ear. My God, there is no provision. No provision. We'll come little later because once we finish that conversion portion, then we'll deal with that. As of now, no, there is no provision in the LLP Act, neither in the LLP Act nor in the Companies Act. Then I have to go into the context of a joint stock company and the Chapter 9, Part 9. Then that will take another half an hour. Then we'll try to complete. Then we'll see that whether we can cover that also. See, these are the basic characters which I want to say. Now, the amalgamation is possible. That only probably, unfortunately, I have to say that we are in the verge of convincing the company code that LLP can be merged with the company by virtue of the definition available in section 391, 394. But unfortunately, that definition is disappearing in Companies Act 2013. So, I don't know, really, it is going to be a good time for us in Company Act 2013 to merge LLP, whether the company code will admit the application to merge LLP with company. But as of now, company code will admit, because by virtue of the definition available, 391, 394, which clearly defines what is transfer or company. Incorporation in Form 9, the format is given. After that, the LLP agreement can be signed. Is it possible we can sign an LLP agreement before forming LLP? Before signing the paper? Or before LLP comes in, can we enter an agreement? It's possible, very much possible. Only thing is, the LLP agreement should be ratified by the partners once the LLP promoted. The LLP agreement has to be filed within 30 days from the date of registration. Here the important point to be noted, many LLP, they are registering. Once they see the certificate, they are feeling so happy, they are leaving it. In fact, some of my known companies, where they took the certificate from LLP registry and failed to file Form 3, now the penalty got accumulated to 25,000 per day, 100 rupees. So now neither they can't they can file without penalty, nor they can't keep without filing it. Either way, it is a violation. Either way, they have to do only. So this is a major disadvantage that we were facing in LLP, where the LLP also, many of us were not preferring LLP because of that reason only. But anyway, as he said, we have to try to be so disciplined and see that we are governed by the completely, and we are governing ourselves to ensure that we are following the provision of the LLP Act. We'll move on to next. These are the basic information about deciding of partners and obtaining DIN, DSC. I don't think I need to explain more on this, as it is, we are aware all the same procedure only up to name availability. After that, in case of company, we are preparing memorandum association and article AOA and MOA, and we are signing and filing. Instead, here under company LLP, we are filing agreement. This is a basic difference between up to the name, almost a similar procedure is being followed in LLP. As we deliberated just before, resident in India, as it is 182 days, during preceding 1 year, important to note, and designated partner DIN now. In fact, earlier we were struggling to take DPIN. Now, once for all, government came out in 2010. They took a decision. They integrated both DPIN and DIN. In fact, we were struggling like anything to take a DPIN. Now, after that, they understood the difficulty and integrated both DPIN and DIN. Now, if DIN is sufficient, if a person has DIN, then it is sufficient to form both LLP as well as company. I think these are basic points, digital signature, and these are the steps that I explained just before: filing of Form 2, Form 3, and subscription sheet that we have to attach. It's not like that where under Companies Act where we mention the name against the subscriber name, shares, how much shares a subscriber are subscribing. Here we need not to mention any contribution portion. It is sufficient the name and signature is there in the subscription sheet to ensure that the person with the knowledge of the person only is getting registered. That's the whole idea about that. An important thing here, stamp. How much value of stamp paper here used in partnership firm? 2000, right? Same value has to be used for LLP also. In Chennai, partnership firm to be done in 300 rupees under Tamil Nadu Stamp Act. Here 2000. Whatever is applicable to the partnership firm agreement, the same thing is applicable to LLP agreement also. Form 7, 1, 2, 3, we are used to this now. Certificate of incorporation. Designated partner. In fact, adding to previous speaker, where he said the designated partner is signing partner. Yes, it's off right. The another office is completely responsible to comply the entire provision of the LLP Act. That is just like a director under the company, where a director is expected and obligated to comply the provision of Companies Act by virtue of a default, the officer in default. Same way here, the designated partner will be the officer in default. So designated partner can't simply sign and stand away from his responsibility. Whether he sign or not, he is a responsible fellow who has to take responsibility of the compliance of the LLP provision by LLP. That's more important to. And as it is same resident in India, one of the designated partners should be resident in India. In case of company, in fact, a company cannot be a designated partner if there is one individual, one company. But the LLP should have a minimum 2 designated partner. What to do? Anyone has come across this situation? So, a designated partner need not to be a partner also in profit. That's what I am trying to say. Though that terminology designated partner looks, a designated partner should first be a partner, then only a designated partner. Just like a managing director. A managing director is expected to be a director first. First he should be in the board as a director, then only he can be escalated as a managing director. Without bringing him to the board, he can't be appointed as a managing director. Same way, as a designated partner, though he should be a partner, then he should be escalated as a designated partner. It's not so in case of company is a partner of the LLP. When company is a partner of LLP, a body corporate cannot act as a designated partner. Just like a Companies Act, a body corporate cannot be a director of a company. Here, a company can nominate an individual to be designated partner. He need not be a partner also. In that scenario, pardon? I am telling a scenario where one individual, one company. Okay, if both are individual, both will be deemed as a partner. In case of corporate, one more person has to be, individual has to be nominated as a designated partner.
Between two companies.
Yeah.
Between two companies, there may be two designated partners who are actually not partners at all. But through nomination they get. So that's like that.
Right. We have seen penalty fees, filing fees under Companies Act where we pay 200 up to 5 lakhs and 300 up to 5 lakhs to 25 lakhs capital, and above 25 lakhs we pay 500 rupees. Same slab here, it starts with 50. This is another advantage running LLP, where there, as he said, previous speaker, there is no minimum capital requirement for LLP, just like a company. But penalty fees also is very less. 50 rupees if it is less than a lakh, and 100 rupees if it is less than 5 lakhs, and 150 less than 10 lakhs, and 200 if it is more than 10 lakhs. And maximum is 200 only here. Under Companies Act, we pay maximum of 500. And designated partner, as it is nothing great on that, the same 274 disqualification under Companies Act 1956 has been brought, almost similar to that disqualification. And if the person suffers this disqualification, he cannot act as a designated partner. Partners' contribution. Here I want to little deliberate in depth, little in depth. As it is under Companies Act, where a shareholder, an investor is permitted to bring either by cash or by in kind. Section 75 gives a reference to us that a contribution, a money can come into the company either a cash or in kind. Here under section 32 of LLP Act, which says how the contribution should be dealt with, and it can be tangible, movable, immovable, intellectual, other benefit to LLP, including money, promissory note. Okay, as usual, fine. Here I want to little more go into depth. I want your answer. If you keep quiet, I'll also keep quiet. I'll move on next one. Whether a person has to contribute or whether the partner should bring money into the LLP to become a partner. Can I make one partner bring 10,000 or 1 lakh rupee, another partner is not bringing anything? Still they are partner. Is it possible? No. Pardon? Possible. In fact, this point, why I throwing this forum, the same debate was happened long back in 2009 itself, in many forums, where I also throw this point to representatives and other things. But that time it was debated that person without bringing money cannot be a partner. He has to bring a money to become a partner. But the scenario is not completely got changed. Earlier deep in and all will be given only if he brings money, and those restrictions and all not there now. And more so, as many members deliberated here, if you see the sections, it permits other services and any other kind also. But still I don't know how many has come across a scenario where a partner is inducted as a partner. A person is inducted as a partner without bringing money. Yeah.
Intangibles are allowed under the Act. So if I have intangibles, then I am entitled to bring
No, it's not that intangible. Because of that intangible alone we are allowed. I'll read the language which permit us to make. Form of contribution, that's so important. In fact, the same para which I read that time also, when I was debating with one spokesman and government representative, that time it was debated and no, he was not agreeing. A contribution of a partner may consist of tangible, movable, immovable, intangible, other benefit to limited liability partnership, including money, promissory note, other agreements, to contribute cash or property, and contract for service performed to be performed. I want you to note down the last one only. It's not that I should have done something. I will do something. Just an agreement is sufficient for me to get into partner LLP as a partner. Fine. Why I have to bring something? Because the next para says the monetary value of the contribution of each partner shall be accounted. That means even though I agree that I will do some service in future, now I have to quantify now and I have to bring into the books of accounts the monetary value or consideration that are. Then only the whole percentage can be arrived and the partnership agreement can move forward with the understanding of the contribution percentage. So it is a basic necessity as per section 32. It mandates the LLP to registered monetary value of the contribution of each partner in the books of accounts. Fine. And next, one more thing I want to hear. Obligation of contribute. This is at 33. This is so important. There is only 2 sections which deals with the contribution. If you understand these 2 sections, then we need to worry about contribution part in LLP. Obligation of partner to contribute money or other property, same other benefit or to perform service or limited shall be as per the LLP agreement. So the another ingredient is the same thing should come in the LLP agreement. So without something coming in the LLP agreement, no one can become and the whole service should come, and the monetary value also should be recorded, should be quantified. This is another important this thing. Anyway, next para is not this thing. So this is the basic thing which we need to understand. A contribution can be in any mode. A partner need not to bring money. It can be in any form, just like a company. Yeah. By all means, private company is permitted. Without any, there is no cap at all. As long as company is going to pay authorized capital fee, they are not going to bother.
Limitation is only minimum, not maximum.
Minimum is 1 lakh, maximum there is no prescription under the Companies Act.
No. For company, will be affected deemed dividend provision?
Company, sorry?
For deemed dividend provision, if it's invest in LLP, so it will be effective deemed dividend in the private.
You are going to section 222 of the Companies Act.
Yes.
That will be dealt with the post lunch, right, sir? Let me not enter into that territory. Okay, you want to finish and go. Okay. No, I don't want to enter. So it's not I'm not the proper person also to deliberate, and though I know it, and probably I don't enter into the territory of other speaker also. And as you said that separately, you need a separate section how to deal with the situation of deemed dividend 222. The whole India is with one question we can't deal with the situation that. Yeah, this annual compliance, of course, in the first session itself is explained much. Conversion. This is a procedure which we already deliberated. Same, I put it in a flow. Now we will go to conversion. In fact, Schedule 1, which is equivalent to the Table A of the Companies Act in case of private company, 1956, Table F of the Companies Act 2013 in case of private company, Schedule 1 in case of LLP, with regard to bylaws of LLP. Fine. What Schedule 2, Schedule 3 and Schedule 4 dealing with? Schedule 2, second schedule is dealing with the conversion of partnership into LLP. Third schedule dealing with private company into LLP. Fourth schedule dealing with public company, unlisted public company to LLP. In fact, we need not to too much complicate the whole thing. The only thing that we have to ensure, if it is a partnership, if a partnership is getting converted into LLP, we have to ensure the same partner, same percentage is coming in the LLP. That is one parameter. In case of company, the shareholding of the member should be represented the same way in the LLP as a contribution. There should not be any change. There should not be any introduction also. It so happened, some people, they introduce in the LLP when they are converting. It can't be done. It is nothing but, it's conversion. It's not a new incorporation or registration. It's getting converted. So nothing new can be added in that. Whatever the capital standing in the credit of the partnership firm, same should be credited in the capital of the partners in LLP. Same way for the members in the partners of the LLP. Whatever the shareholding of the members, the same thing should be represented in the LLP by partners. The only one difference between the private company and private and public company and partnership conversion into LLP. If a partnership is getting converted into LLP, this is the only thing which I told you that we have to ensure the percentage is matching. But in case of private company and public company getting converted as a LLP, in addition to that, we have to ensure there is no charge is filed by the private company and public company. This is a very important thing which many people they probably forget or may not aware. Before converting, they convert, then the system says the company has registered Form 8, so this company cannot be converted. So you satisfy the charge and come back to the conversion. So we should ensure before converting company, whether it's a private or public, into LLP, we should ensure we are going and seeing the register of charges which is available in the MCA, whether any charge is reflecting or not. If a single charge is reflected also, that company cannot be converted into LLP. This is very important point that we have to keep it in mind. And except these 2 points. There is no other precautions or point that we have to keep it in mind. The first one, the percentage which I told, the members, whatever the percentage, the same member should become the partner in LLP, in the same percentage. Of course, you know, section 45 and 47, with respect to income tax capital gain provision, that condition has to be met out to see that you are coming out of the capital gain implications. And eligibility which I told, yeah. Yes, it has to. You can't get new name, different name. In fact, the private company can be converted. Vigneshwara Enterprises Private Limited has to be Vigneshwara LLP. Suppose the LLP says there is no other name, we can't give that name. The possibilities are there. We are getting also that kind of getting into that kind of issues also. So, sometimes in that case we have to ensure we are changing the company name and converting LLP. It should not happen, but in a scenario, exceptional scenario. In fact, it so happened that issue in partner in conversion. In partner in conversion, our people, Sri Lakshmi Enterprises, they may be doing 50 crores turnover for 50 years. When I try to convert into the company under part 9, I won't get that name because 100 Sri Lakshmi is registered already. Now they will say, no, you can't. Though you are 50 years, fine. But under companies that I can't give you because so many companies got registered now. So what we have to do, we have to ensure that what name we get, what name is made available by registrar of companies, and we are changing that name as a firm name, then we are converting the firm. This is practically happening because of this name issues. No, you already would have paid fees only, no? Accordingly you have to pay. Whatever the contribution you are bringing in, no, accordingly as per the slab you have to pay.
No, but if we make that firm into a LLP, do we need to pay that much fees? Means I am talking about the fees.
No.
Lesser.
Lesser only.
Three-wheeler. The concept of four-wheeler, three-wheeler applies.
Okay,
Same
so
thing.
we need not pay that much fee.
No. That is a basic advantage.
Kam matlab kitna kam?
Maximum 5,000 only. That's a basic advantage.
Okay, so that 5 lakh comes down to
No. That is the biggest advantage in LLP that we have to pay maximum 5,000 fees. 5,000 maximum.
So that advice you can give.
You can advise. Only for that matter you want to convert. Fine. Sir, please convert. No, what you are telling?
Trying to make it a company, now I'll try to make it a LLP. Client will save around 5 lakh rupees.
That's what I am telling you. Please convert. Convert. I understand your concern.
The fee structure is very clearly given in the rules, Annexure A, where it says limited liability partner whose contribution exceed rupees 10 lakhs, 5,000 rupees. You will have to pay as royalty now. 4,95,000 rupees into 10% at least.
Yeah, please. Yeah, please.
What's the implication of stamp duty for revenue records?
What is the implication?
Of stamp duty when the immovable properties are involved?
Yeah, I am just coming to that, sir. Yes. Before that, there was a discussion. I am coming to that only. In fact, my next slide is going to talk that only. Effect of registration. See, what is the effect of registration? Suppose I have a property in partnership firm, leave it all partnership firm. First of all, we are discussing that I can't hold the property. Let us discuss company. A company holding a property in its name, a 50 crores worth of property. I am converting the company, private company which is holding the 50 crores property into LLP. Your concern is, do you have to pay the stamp duty? That's what the concern that you are raising now. Okay, fine. Wait, I am just coming to that only. See, now as of now, there is a vesting provision provided in the list partnership by LLP Act. What is that vesting? In fact, the same vesting provision is available under section 394 when amalgamation demerger is occurred. The section 394 says that the moment the High Court approves a scheme, approving a scheme of amalgamation or scheme of demerger, by means of a vesting provision, the property and liabilities of the demerged or transferor company becomes transferee company without doing any further act. The same vesting provision is available to LLP also. In fact, the same vesting provision is also available to partner in conversion also. What is the vesting provision? The vesting provision is, it is not that a change of the property or transfer of the property or transfer in a different form. It's a change in the status. Here, the entity status alone is getting changed. This is not, should not be considered as a transfer. That's why the lawmakers, they bring as an inbuilt provision the vesting provision. When it is, should not be deemed as a transfer, then it should be deemed as a vested one. That means there is only a change in status, not change in ownership. That's the reason we deliberated now, and the law says that we have to have the same shareholding and there should not be any change in the shareholder. Why? Because this is not the transfer. This is not a change of ownership. There are going to be the same owners. So this is only status of company into LLP or partnership into LLP. By means of that vesting provision, we need not to do any further documentation. In fact, the property which is standing in the name of private company, by virtue of conversion of private company into LLP, by law it become, by virtue of law it become property of the LLP without doing any further act. See, there are two things are there. One is by virtue of law, by evolution of law. One is by act of parties. We say act of parties in the Transfer of Property Act. And implication of law, by virtue of law. Where by act of parties, when two person does something, then it considers a transfer, then it is subjected to stamp duty and registration, all that formalities. Because it is action of the parties. Whereas this is not action of parties, by implication of law. Here there is no action in between the parties. This is only a process whereby we are changing an entity from one status to another status. By means of vesting provision, we need not to do any further documentation, whatever it may be, whether it is a movable or immovable, whatever it is, whatever standing as a assets and liability in the books of the company, by virtue of converting into LLP, that will deem to be the assets of the converted LLP. That will stand as a assets of the converted LLP. And
you have to notify the authority.
Pardon? We have to give details.
No, you have to know.
Whatever there in the books of account, that anyway we will be drawing out a balance sheet before we are converting company into LLP. We have to clearly list out what are those assets.
If you look into point number 8 of Schedule 2, there it says registration in relation to a property. I mean, all of you can go through that. In fact, Schedule 2, there are two interesting points that emerges out of this question, which is effect of registration, it gets vested. Now, there may be one issue, as he was mentioning, Sri Lakshmi Enterprises. The property is in the name of Sri Lakshmi Enterprises, a partnership firm. That is another question. Whether a partnership firm can hold an immovable property has been debated. If you look into point number 7 of Schedule 2, under that B, Schedule 2, point number 7, point number B, all tangible, bracket movable and immovable. That means LLP Act acknowledges that a firm can have immovable property. We'll leave it at that. That is one point. The point, the further that comes out is, without any further act, assurance or act, it stands vested in the new entity, which is LLP. Now if you come to point number 8, if any property to which subparagraph 7b applies is registered with any authority, which is a sub-registered authority, the LLP shall, as soon as practical after the date of registration, take all necessary steps as required with the relevant authority to notify the authority, underline the word notify the authority, of the conversion and of the particulars of the LLP in such medium and form as the authority may specify. That is where
nothing is specified. Nothing is specified.
No, who has to specify? The sub-registrar in Karnataka has to specify.
Yeah.
Now, whether they are aware of LLP at all. That will be. And what is a document on which we have
it's not a sub-registrar. In fact, the whole sub-registrar office in Tamil Nadu or whatever the state, it's controlled and governed by the IG registration, Inspector General of Registration.
No, that is what the state
They
authority.
have to come out with saying that. In fact, how it's coming in for amalgamation. In fact, as you are aware that new Tamil Nadu Stamp Act going to levy stamp duty for amalgamation. In fact, already many states already it is there. Oregon, Bangalore. Here, in fact, Tamil Nadu, we were enjoying that benefit of not paying stamp duty for amalgamation. Now they brought that amendment. Now it is there. Like that, they have to come out. If they come out, then we can't stop.
No, but till then, what is to be done? That is a big question.
Till then, no further act is required. That's what the...
No, I mean, that is a bigger question to be notified. Which is to... No, that is a question. No, that leads to, I mean, I'm just telling you, Sri Lakshmi Enterprises held a big property worth 100 crores. Now it wants to actually step up to LLP. Okay, and that name itself is not available. Sri Lakshmi Enterprise, I always say this. If Sri Lakshmi, when goddess Sri Lakshmi comes, she will not get her name. That's another question we have. Now, having said that, now it is now registered as SL LLP. I mean, every name should have its suffix as limited liability partnership. So SL Enterprises LLP. That is the name of the new entity. Earlier was Sri Lakshmi Enterprises. Now suppose you want to sell this property. He will say this is not registered in the name of SL Enterprises. So that is where the link document is your conversion document. So your Sri Lakshmi Enterprises, your conversion document together becomes the mother deed for your sale deed to happen. But
no, your point is correct only because we have to notify the change.
To that extent, there is a defect saying that.
In fact, if you see the point number 7, that only it's written. I have written registration in relation to the property. Authority with whom property is already registered to be notified by LLP about the conversion. It is enough you send a letter. But that too, as soon as practical, all this is there. So we can always...
No, but that will be, as you said about the...
Just like our CSR.
No, Inspector General of Stamps, maybe then they will wake up and say we are missing out on the stamp duty. That may be a bigger issue, which I think
they can take up. Yeah, see, if government decide they can do anything. They can even say that you should not conduct seminar also. See, that is different. But the thing is that till that time we are enjoying that privilege. Till they come out and say don't do this. We can enjoy that privilege. Yeah, correct. But it's duty of the LLP to inform. Then only the registrar will be knowing. But I really doubt how registrar will keep the control of whole thing. That's only my doubt. Because reason being, I know how the registration office is working. In fact, in my experience, it would have more than 500 acres. I would have done the document scrutiny and represented. But no registrar office has got that program or this where they can keep track of whatever the communication is coming. In fact, only an high court gives an instruction by virtue of an order. Then only they bring into the system. Otherwise, generally they don't bring into the system. Then how they will keep track only is a matter. As you said, a property, every jurisdiction has got so much of property. Even we notify also, I really doubt how they can able to update the system as there is no provision. As you said, probably the Inspector General should give instruction to the sub-registrar. If you get a letter from like this from a LLP, that should be updated. I think
there may be another issue saying that we'll have to look into the Karnataka Stamp Act for Karnataka purpose. For all other purpose which has not been told above, you will have to pay X number of fees. Maybe I don't know if that has to be applied or because for notifying there may be.
I don't think. No, it can't be generally. No, it can't be generally put like that, sir. Then we will get into trouble only.
This is notification.
Yeah, then. No. We can't make it very general. Yeah.
Sir?
No, so far nothing has come. I'm sure nothing has come with respect to LLP.
Nothing has come
with respect to LLP.
In all the states in India?
I don't think so.
To my knowledge, subject now. That's the.
To my knowledge, does not come.
Yeah.
No. In case of amalgamation, when we hold any property, or shares, then we send the shares to the company, let's say outside other company, and they get it transferred in the new name generally. Even the property.
Correct.
But in this LLP, they have not made the provision.
No, the agreement is there. Here, in the LLP agreement, the shareholder is going to be the party of it.
No, I'm saying holding property, okay. About the changing in the property records, the name, new name.
So there is no process for amalgamation also, there is no process like that. See, if you, in any property for this matter, if a company get merged, amalgamated in another company, suppose the property is there in the transferor company, it is sufficient along with the sale deed if you attach the court order. For all purpose, the property should be treated as a property of the transferee company if the court order is attached.
No need to change
No
in
need,
the registration.
no need, nothing. Now only all the stamp duty, this thing will come. Now the procedure they may come out. Yeah, we'll move on further this thing. And certain comparison I have made between the company and LLP, where what are the benefits that the LLP have. Of course, statutory meeting and maintenance. Of course, I request Mr. Acharya to intervene and see whenever you want to stop. As I told you, my PPT will run only. Yeah, please. So these are the benefits which I captured between LLP and company. Statutory meeting, maintenance of register, all this is not applicable to LLP. And remuneration, of course, we are free to deal with. It's not like a company where we are restricted by so many provisions on remuneration. And contracts, they are free to deal with that. And maintenance of statutory records is not required for LLP. Annual filing, same as company, as we have deliberated in the first session itself, much. And audit of accounts, which I explained. All LLP except LLP having turnover of less than 40 lakhs. Same way, 25 lakhs contribution, should their accounts get audited by a statutory auditor. And accounting standard, of course, so far it has not come. And if it comes, then it has to be followed. And now auditing standard also become mandatory for, going to be mandatory for company under New Companies Act 2013. And this is a Form 8 which we have discussed in the first session itself, where it's an equivalent form to 23AC, ACA, and a Form 11 equivalent form to 20B, which we filed for annual return to company.
It's a statement of account and solvency.
See, the solvency is a capacity to pay. That's what the solvency. That means they are wanting us to list out what is the liability and what is the asset you are keeping to match out the liability, and you are in a position that you can deal with the creditors or liability, and you are comfortable in a way whereby you can pay the liability. That's what a solvency. No, we should not. No, we can't. As you said, contribution, if it goes negative, I can't close the LLP. As I said, the solvency is a capacity only, they said. Again, I have to say that there is nothing there defined that what solvency refers to. And when the LLP will be concluded or will be inferred as an insolvent. Yeah, correct.
Now, I will give you an example where the contribution is 2 crores and your reserves and surplus is minus 5 crores. So, can you certify that it is solvent? That is the question.
You have to.
No, let's go into the dictionary meaning of solvency. Solvency means where the assets are more than the liability. I mean, in my opinion,
fine, that 2 crores should be represented by some asset, no? You are meaning to say in the old schedule. Now under revised schedule 6, anyway we are detecting the loss in the reserves and supplies itself.
Correct.
So no asset is represented under revised schedule 6.
No, that means I have borrowed, actually.
Yeah, yes.
I have borrowed.
Yeah, it's
See,
equal
2 crores
only.
minus 5 crores. My balance sheet total is not minus. I have taken the 3
correct,
crores
correct.
and then I have got the 3 crores asset.
See, as long as...
So that is what...
Yeah, I understand your concern.
Whatever it is. I mean, your expenditure is minus 5 now. No, that is the question. You will have to maybe amend your LLP agreement to say my contribution is going to go up to 5 crores such that the negative becomes
as long as there
positive.
is no parameter prescribed under LLP Act, how much ever we debate, it is not going to help us. The reason being there is no parameter prescribed.
It's question of certifying. That's
what the question of that you got convinced with the situation, nothing else. Suppose I tell something to you now, which Registrar of Companies may not agree. I'm just telling.
We will pose it.
You tell something to me, which I agree. Department says, no, I can't consider this. So, which is going to satisfy that what you are certifying is really a solvent? Correct? There is no answer. That's what I am trying to say. Your point is 10 crores negative.
Where someone is insolvent, you can't make it solvent by certification. It's very, very clear.
You can't.
Negative net worth has already come up as indicated. There is
No, you can't make it solvent, but whether you are certifying, that's what you are this thing. You are taking a chance there.
You can't say that I'm taking a chance. What I'm asking is what is the correct?
No, there is no correct. That's what I'm telling. There is no parameter prescribed.
Say that you're not satisfied. Yes.
Yeah, exactly. As you said, as a professional, we have to apply our judgment, see whether I can certify this, whether according to me this is okay. We can deliberate more. But still, what the financial statements refers, that only is going to make you to take decision. What today I am telling is not going to help you out at all, unless you can't substantiate. No, correct. See, very clear. You are asking expert opinion only. No, then you have to get convinced with my opinion. Correct? As long as, yeah. So please get convinced. I am telling that. As long as you believe that you can substantiate, okay, and you are convinced with a stand that you are taking by signing, then it is solvent. I am an expert. I told. Oh, then again you are asking. See. Sir, you are at liberty to qualify and say that the solvency is questioned. Very simple. Something we are not. Yeah, exactly. You are at liberty only, no. Even whether I say or not, still you are at liberty only. Yeah, correct. You are at liberty.
Solvency will be more at question. Solvency will be more at question if you delay.
See, no law in our land and no provision in our land or no regulatory authority in our land should compel a professional or any person to sign something without expressing his opinion. See, as we are a professional, we are signing, we are permitted or we are at liberty to express our opinion. There you can put whatever they're saying that according to you that something solvency is questioned in the statement, or you are not convinced with the solvency. You can always negative. They never say that you put ensure that it is solvency, then you certify. It's not that. You have to have a statement there we have to ensure that you are putting a negative remarks on that. No. I don't. There is no provision. No, there is no provision that by certifying. When a statutory auditor, when he certifies that there is no solvency, that amounts to, or that will lead to winding up, there is no provision. So you are just informing to the department and the partner, saying that the solvency is questioned, I am not convinced with the solvency. As a professional, we can apply our judgment and, yeah.
Go to the Form 8, the language of the Form 8, they have embedded the situation. I will just read out the paragraph there.
Yeah, please.
What they say, so-and-so being the designated partners of the representatives of so-and-so LLP, do solemnly affirm.
Point number?
Second paragraph,
Form 8 you are telling, okay, which serial number? Instruction you are telling, or form itself?
Form 8, statement of solvency.
Okay.
That gives the answer. The declaration they say the LLP as limited partnership is able to pay its debts or is not able to pay its debts.
Correct. But it says you have to say that whether it is able to pay or not able to pay. Yeah, correct. You have to say, but that is not going to lead winding up. That is not going to lead winding up. That's what the point here. It is not going to lead the winding up. Yeah. Fine. Anyway, as our session chairman says, we can close. We'll deliberate maybe post lunch.
We'll discuss.
Any doubts you can ask me post lunch. So we'll break for lunch.
Thank you, sir.